You're tuned in to Agriculture Today, and we start our Wednesday show with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you, Shelby.
Roger, as we've started a new year, we always look back at the previous year and discuss your top 10 developments when it comes to agricultural law and tax. And starting off with number 10 today, pesticide litigation. And what does this mean?
This is the Roundup litigation, Shelby, that's been going on for a number of years across the country, and it really heated up in 2025. And I think at the heart of the conflict is federal law and the question of federal preemption. Does EPA approval of a label prevent consumers from suing under state failure to warn laws? And we've actually developed a split of authority amongst the federal circuit courts across the country. And we've had states try to come up with shield laws. It's been successful in some states. It's not been successful in other states. There's been some big jury awards across the country. And right at the end of 2025, the U.S. Solicitor General asked the Supreme Court to take up a case to clarify the matter and clean up the split between the circuit courts. So I think we'll probably see that happen in 2026.
Something else we talked about at the end of 2025, a case happening in North Dakota. And what is this one involving, which is your number 9?
What you had was a statute that North Dakota passed known as their CO2 storage law, carbon dioxide storage law. And it said that if a company got 60% of landowners in the path of a project and got them to sign up to grant easements or ownership over a right-of-way, whatever it might be, over their property, and the other 40% didn't want to do that, then the 40% were bound by the 60. That's known as the amalgamation concept. And the court struck that down as unconstitutional. They said that the pore space beneath the surface is a property right that the owners of the surface own, and that cannot be taken without compensation, which the court felt is exactly what happened in this case. And there are other states across the country that have similar amalgamation laws, and I think the North Dakota Supreme Court will likely uphold what the trial court said, and that's going to have implications in the energy industry across the country.
As we keep going through your top 10, what's your number 8?
It's a tax development, and this one is kind of another one of those that is all over the country with select farmers and even ranchers now. And this is the idea of being able to allocate a part of a purchase price or the cost of land that you've inherited, take some of that value and allocate it to residual fertilizer supply or excess fertility in the soil and for the nutrients in the soil. And we don't have a statute on this. We don't have any regulations on this. We don't have any cases on this. All we have is a tech advice that the IRS put out in 1991. It became public to us in 1992 that said, well, if you can measure the amount of nutrients in the soil and determine what the prior owner put on and show that it's above some sort of baseline, then you can allocate value to that and receive a deduction for it. We got a lot of unanswered questions on this. We don't know whether it's depreciation. We don't know whether it's amortization. We don't know whether we can use what's known as a Form 3115 and go back in prior years and catch it up if we didn't take it in a prior year after acquiring the property. And I've seen some massive, massive deductions. I saw one that I reviewed was $40 million deduction allocated to residual fertilizer. And of the audits that I'm aware of, I haven't seen the IRS make any changes on it. So that may indicate that they're kind of timid in wanting to challenge it because they don't have a statute and there's no regulations on it. And they may still be learning about it. But this will continue to be a hot issue in 2026.
And looking at your number 7, a case that's taking place in New Mexico.
Yeah, this is a federal district court case out of New Mexico that's on its way to the 10th Circuit Court of Appeals, of which Kansas is a part. And this is the notion that the public trust doctrine and its impact on private property rights is pretty substantial. And what I mean by this in terms of what happened in this case is the courts upheld a New Mexico law that said that if you own ranch land, you own farmland, you own rural land, and the public needed to get to a stream, a non-navigable stream, and the only way to get there was across your property, they had a right to do it. You couldn't exclude them. And they upheld that as constitutional. I think it's directly contrary to a U.S. Supreme Court ruling in 2021. This is a big issue, though, because they said that, the waters in these streams are owned by the public. The public has a right to them. If your property happens to be in the way, well, that's too bad. That shows us how broadly construed this public trust doctrine is by some courts.
And for number 6, a case that involves ranchers and a product of the USA beef label.
This is a federal court case filed up in South Dakota, and the ranchers that brought that case against the Big Four meat packers prevailed so far in a motion to dismiss the case. We'll see what happens on appeal on this one, but this is the issue that the product of USA label on beef doesn't necessarily mean that that beef is born, bred, raised, and processed all in the United States, because there is what some would call a loophole in the law that says as long as it's the final processing step is here, then that can have a USDA product of USA label on it. And that's not necessarily true. As I said, that could be a foreign animal. So we have ranchers that are challenging that. And so far, this case is continuing. It's still a live case. So the meat packers, of course, they argue that because the USDA previously approved the labels, state-level consumer protection and antitrust laws are preempted by federal law. And we'll see what the Eighth Circuit says. But if the Eighth Circuit sides with the ranchers, it's going to set a precedent allowing states to police deceptive corporate practices, even when those practices enjoyed federal stamps of approval.
And what's coming in at your number 5 for 2025, Roger?
A whole bunch of antitrust issues is number 5. We saw this happen in 2025 with respect to right to repair. We saw the Farm Act introduced in the Congress in late 2025 that tries to codify a farmer's right to bypass authorized dealerships in favor of independent mechanics. And then we saw antitrust cases brought with respect to price manipulation in the meatpacking industry and wage manipulation in the meatpacking industry. We also saw some wage fixing schemes in the poultry industry. These cases resulted in settlements, major settlements in some of them, and also additional litigation in the poultry industry about bid rigging. And then at the end of December, we saw a new executive order establishing task forces within the Department of Justice and the FTC. So antitrust issues were big in 2025, and they'll continue.
How was the National Environmental Policy Act involved in your number 4 development?
Well, the U.S. Supreme Court decided unanimously in 2025 that the scope of NEPA was too broad. And NEPA is the law that federal agencies have to comply with when they produce a new rule, when they produce a reg. And they have, under the prior interpretation, they had to consider what we would call downwind or downstream effects of a particular regulation. And a lot of those were tied to so-called climate change and greenhouse gas issues that maybe that regulatory agency had no ability to do anything about. But if this rule would have impacted what they thought would have been greenhouse gas emissions, climate change issues, then they would get tied up in a bunch of bureaucratic red tape, and they'd have to go back and have more hearings and so forth. The court said that's unconstitutional. The agencies are only responsible for what they can control. And so you don't have to analyze the global impact, for example, of livestock methane emissions before renewing a permit. And so this is a big one for agriculture. It's going to translate to lower costs and faster approvals and a major reduction in bureaucratic red tape that has hampered farmers and ranchers on certain things they wanted to accomplish for decades.
And number 3, an example of it, takes us back to South Dakota. And what's this development?
The lead development on this issue came out of South Dakota in 2025. The development is Lawfare, where we've seen bureaucratic agencies really kind of target farmers and ranchers, it seems like, on a number of things. And the Maud case out of South Dakota was the big one. That case involved a 75-year-old fence line, a 25-acre parcel, and the family, a fifth-generation ranching family in that area, had managed it cooperatively with the Forest Service for decades. But rather than just a civil boundary case, this got into criminal indictments, and it took a change in administration to get the USDA to remove the criminal charges, and now they're back down to negotiating some type of deal over the border on that case. But the USDA, near the end of 2025, established a portal on their website, a Lawfare complaint portal, where they are accepting information on other Lawfare instances. So that was a big issue in 2025.
And something that I feel like comes up a lot when we talk, Roger, involving the waters of the United States, and that comes in at number 2 for 2025. Yep.
Back and forth we go on WOTUS, and we got some regs proposed in 2025. In fact, the time frame for submitting comments just recently has expired as you and I are talking. We've had a narrowing of the definition, and it's going to remove federal jurisdiction over a lot of ditches, a lot of streams that sometimes have water in it because there's a continuous surface connection requirement. So very favorable to agriculture is how I see that one.
And the hot topic of 2025, it feels like, as we talked a lot about it, the One Big Beautiful Bill Act coming in at number 1.
That is number 1. We've got 100% bonus depreciation, a ramp up in Section 179. We got an estate tax exclusion of $15 million. We avoided a major tax rate increase across the board for everybody. And another big one is the continuation of the qualified business income deduction, a 20% business deduction for any entity other than a C Corp. And then, of course, we got the commodity title. We got higher reference prices, loan rates, favorable changes in crop insurance, and that was all in the commodity title of OBBBA, and I've got that at number 1.
That was K-State and Washburn law professor Roger McEowen. You can read articles on the top 10 developments in ag law and tax in 2025 on agmanager.info.